Hello and welcome. This brief encounter is with international relations, or rather, a more niche subject in international relations: extradition. In light of the recent extradition issue of Sheikh Hasina, the former Prime Minister of Bangladesh, from India, we shall look into extradition through four questions. First, what is extradition? Second, what is an extradition treaty? Third, what is the extradition treaty between India and Bangladesh? And fourth, is there a possibility for India to refuse the extradition request by Bangladesh? We will look into all four questions, starting with the first. What is extradition? Extradition is the formal process of one country surrendering an individual to another country for prosecution or punishment for crimes committed in the jurisdiction of the requesting country. Extradition is typically enabled by a bilateral or a multilateral treaty. However, extradition sometimes may also take place without a treaty, although that is very rare. It is regulated within a country by acts which state how a country is going to go ahead with it, and the process of extradition that is going to be carried out between two countries is stipulated in treaties. The first act providing for extradition was passed by Belgium in 1833. It also passed the first law on political asylum. What is an extradition treaty? An extradition treaty states the procedure and the conditions in accordance with which extradition between two countries shall take place. In the absence of an extradition treaty, a country is not obligated to fulfill the extradition request by another country. Which means that if there is no extradition treaty between country A and country B, then if country A asks for a person to be extradited from country B can refuse the request. However, if there is an extradition treaty between country A and country B, and country A requests for an individual to be extradited from country B, and the conditions of the extradition meets the treaty, meets the terms of the treaty, then international law directs and obliges country B to fulfill the request. There are two things which we must keep in mind when we are dealing with extradition treaties. The first is the subject of double criminality, and the second is the subject of political offense. Double criminality means that extradition will take place between two countries only in cases which are considered to be an offense in both countries. Which means that if country A asks for an individual to be extradited from country B for an offense, that offense must be considered as a criminal activity, or it must be considered as serious an offense for country B as it is for country A. Otherwise, the extradition will not take place. Otherwise, the request for extradition shall not or may not be fulfilled. The second is political offense. Most extradition treaties today exclude an offense which has a political character from being one of those situations under which extradition will take place. Which means that if an offense is of a political nature or of a political character, then extradition will not take place. What is an offense of a political character is something we will deal with further ahead in the video. Who can be extradited? 1. A person who has been charged with a crime but has not been tried in court. Second, a person who has been charged, tried, and who has been convicted, but he or she has escaped custody. Third, a person who has been convicted in his or her absence. What is the extradition treaty between India and Bangladesh? All requests for extradition from India are taken care of by the MEA, and specifically the CPV department or division of the Ministry of External Affairs, which is the Consular, Passport and Visa Division. All requests for extradition must be, or ideally should be, addressed to the Joint Secretary of the Consular, Passport and Visa Division of the Ministry of External Affairs of India. The extradition treaty between India and Bangladesh was signed in 2013 and it was amended in 2016. The treaty is aimed at dealing with insurgency and terrorism along the shared border of India and Bangladesh. The intent is to streamline the process of transferring fugitives or dealing with fugitives, especially those who are concerned with acts that threaten national security of either country. The issue or the subject of dual criminality is in operation or is valid in the extradition treaty between India and Bangladesh, which means that extradition between the two countries shall only take place in situations or in offenses which are considered criminal acts in both countries. The 2016 amendment to the extradition treaty between India and Bangladesh eliminated the need for evidence, and now only an arrest warrant from a competent court is required from the requesting country. Can India refuse extradition of Sheikh Hasina to Bangladesh? Yes. According to the Diplomat, there are 2 articles in the extradition treaty between India and Bangladesh which can provide the grounds to India for refusing Bangladesh's extradition request. One of these is Article 6. Article 6 states the exclusion of offenses of a political character from the extradition treaty, from imposing extradition. We come back to offenses of a political character here. Offenses of a political character have not been very well defined in international relations or in extradition treaties, but they refer to offenses that are considered as offenses against the state. Because what is considered an offense or an act of aggression on one state, on one government, may not be considered so by a different government or by another government. For instance, in autocratic or authoritarian or dictatorial states or countries, there are many acts that are considered serious offenses, that are considered serious crimes, which are not considered crimes at all in democratic countries. Or there are certain offenses that are considered to be serious crimes in certain democratic countries, but they are not considered the same in other democratic countries. So the nature of the offense plays a very big role in defining whether an offense is of a political character or not. However, since situations in international relations have become so complicated, there has been an explanation and an elaboration of offenses of a political character. And now, offenses of a political character are divided into 2 categories, pure and relative. Pure offenses are those that are considered that are carried out against states or governments, and relative are those that are carried out against innocent people. These are acts that are usually seen to be carried out by terrorist organizations. And in such cases, even though the acts may consider may have, may concern, may be of a political nature or a political character, extradition is carried out. However, in cases of political offenses that are of pure nature, it's a very gray area, and extradition requests have been refused. Political offenses are usually mentioned as an exclusion to extradition treaties, and it is rooted in the idea of a political asylum, which states that a person should be able to seek refuge in one country for offenses it has committed against the government of another. However, in the extradition treaty between India and Bangladesh, the clause on political offenses is limited, and it is limited by the exemption on matters of murder, kidnapping, and terrorism related crime. So we can see pretty clearly here that terrorism has been the prominent subject in the extradition treaty between India and Bangladesh. It is also quite strange that, considering the long history, the long relationship that the two countries have had, especially as they've been neighbors, the extradition treaty did not exist before 2013. That's food for thought. And even now that it does, the central focal point of the extradition treaty has been terror and insurgency. And the situation with Sheikh Hasina right now does not rest on terrorism. It's a very different issue. So we're yet to see how this is going to unfold, and if this brings further changes or amendments in the extradition treaty between the two countries, apart from the obvious fact that it's also going to test the diplomatic skills of both these countries. The second possibility under which India may refuse Bangladesh's extradition request is under Article 8. Article 8 states that an extradition request may be refused if the accusation is not made with good faith in the interests of justice, or if the offense is a military one not recognized under general criminal law. According to the Diplomat, these two articles provide grounds for India to refuse Bangladesh's extradition request. This was a very short video that dealt with extradition and extradition between India and Bangladesh. If you would like to hear more on the subject, please let me know for a more detailed video on the subject or on any aspect of the subject. Thank you for watching. Do subscribe if this was helpful. See you again.